Welcome everyone, I'm Russell Alexander. I want to continue to thank my daughter Sarah who's helping us film today. Our firm continues to serve clients virtually to ensure the safety of all staff and clients and the public. You can learn more about our safety protocols at our Divorce Information Center at russellalexander.com. So without further ado, let's get into today's topic. Can an order for costs be reduced to the COVID-19 impact on income? In a recent case of Levin, the Court of Appeal rejected an application to reduce costs ordered, requiring the husband to pay a portion of the wife's legal fees. By way of background, the original cost order, in its previous endorsement, the Superior Court of Justice referred to it as a discretionary assessment to determine costs based on any offers to settle submitted prior to trial and the date of which they were submitted to the other party. In this particular case, the wife had submitted 2 offers to settle prior to trial, both of which she declined. Rule 18 sub 14 of the Family Law rules state that the wife is entitled to costs up to the date of the offer was served and fully recover her costs from that date. In this case, the wife was only seeking costs relating to the date of the second offer to settle. In its consideration of the issue, the court assessed the husband's application to dismiss costs at several stages of the case, namely a motion, 2 trial management conferences, a mid-trial conference, and a third-party records motion. The court concluded its assessment by taking into account the consequence that awarding costs would have on the husband's financial situation. It was determined that the husband had earned considerably more than was declared within the relevant financial disclosure and concluded that the cost obligation would not be enough to seriously harm his financial situation in the long term. If you are enjoying this video and find it helpful, give us a thumbs up or leave a comment in the box below. Secondly, the Court of Appeal's ruling on the COVID-19 impact. The husband then brought an appeal seeking to overturn the trial judge's original order relating to spousal support, child support, net family property, and costs. After this unsuccessful appeal, the wife sought further costs on a partial indemnity basis in the amount of $13,585. The husband sought to reduce this amount to $10,000 by relying on the negative impact the COVID-19 pandemic has had on his self-employment income. However, no proof of such economic repercussions were due to the pandemic were submitted. The Court of Appeal concluded that a reduction of $1,585 was reasonable in light of the appeal being heard in writing and not requiring an in-person attendance. To learn more about this case, you can read the full article in the link description below. Please leave us your thoughts and questions in the comment box below. If you liked this video and found it helpful, please give it a thumbs up to let us know. You can subscribe to this channel and hit the bell icon to get notification every time we upload a new video. Thank you for watching.